Okay, and you're counsel, correct?
That's correct.
All right. And we have no counterclaims or cross claims in this one?
No, Your Honor.
Okay, just make sure. I always like to kind of mark myself down here if I know there's some extra things that are happening. All right. Mr. Ferdakis, I'll say that sort of for ease of me understanding and following along, and since we're all together like this, if you can decide amongst yourself maybe who is going to be the spokesperson, that doesn't mean you both can't testify, but in terms of what I guess sometimes people want to talk over each other, and that gets very confusing to the court. So if you'll kind of amongst yourselves work it out who you think would be the kind of the main narrator, that would be helpful. But then what we do is just quickly, you'll get a chance to make an opening statement. What I'm interested in really is tell me if you're suing the defendants for money or property. If you're suing for money, tell me how much money exactly it is you're seeking. If it's property, tell me what property it is that you want to have back. And then tell me kind of what's the theory of why the defendants owe you the money or the property. Is it a breach of contract? Is it a negligence case, like a tort? Is it a personal injury? Something like that, okay? That is not, you don't have to give me all of your information. It's just, it lets me know what am I going to be listening for in it. And then both defendants have a chance to respond. They can also wait until you've presented all of your evidence and testified, and then they can make a statement. They're allowed to kind of wait and see. That's just rules of court. And then after we hear from both the plaintiff, and if you meet kind of a threshold burden, we hear from the defendant, each side's allowed to ask each other questions. When everyone's completely done, we've heard all the testimony, we've seen all the evidence, then you get to kind of finalize it with a closing statement, which is a lot like the opening one that says, see, I'm entitled to the money or the property because of my evidence. All right. That's law school. I went 3 years, took out $100,000 in loans, and I'm giving it to you in 30 seconds. All right.
Thank you.
Worry not. You don't have to worry about addressing me by a specific name or thing. People get kind of tripped up in that. Just don't call me a bad word and we'll be all good. Okay. All right. Please tell me who's going to be our opening.
I will be the spokesperson.
Tell me what this lawsuit is about, sir.
So this is about money, and it's for the amount of $4,234.62, and it is for breach of contract.
Okay.
So the very, very short story is that at the time, my wife and I resided at City in Austin, and we contracted with Baird Services LLC for the building of a pool. The contract was entered on September 17th of 2021. The pool was concluded in April 2022. 2 months after that, we started seeing cracks, pictures of which we have submitted in evidence. And we contacted Mr. Baird several times from June to December, asking for warranty-based repair. He came by, visited, and did admit that this was indeed warranty repair that was not done. Abruptly, in December of 2022, we were told that he went out of business. And as such, he could not fix the damage on a warranty basis. We contacted Premier Pools, which is a franchise. We contacted Premier Pools headquarters, and we started contacting other offices trying to find out who will actually honor now the warranty. On that basis, we actually filed a suit. And in May 2023, we awarded a judgment of $4,200. The judgment was stayed on the basis of the LLC Vail was not able to be because we had sued him personally, and we had to resubmit it. And the suit was resubmitted, and the discussion was that we were not exactly the case. As a matter of fact, today we were not exactly sure who actually owns this warranty now. Mr. Baird has sent us communication saying that all his business is now provided for by the Georgetown-based pool services, ATX. We're told by Georgetown that they're a separate business. We never entered into a contract with them. So there is a contradiction. In the meantime, we actually had to pay a third party to fix the pool because the pool was cracked and such. Mr. Baird has provided us a letter, or I should say an amendment of the contract. I really don't know what it is. It appears to be a legal document, which we've entered into evidence that actually states that all his business and interest, including warranty, is now been assumed by Georgetown ATX. that he has provided to us. So this is where we're at, and this is the case.
When we contacted Georgetown, they said that ours is not part of that. Some of them are part of that warranty, not all of them are part of that warranty, and they deemed that ours was not, and they gave us a quote to fix our pool. We did not go with them to fix our pool. So
Tell me again why Premier is here. What's your claim against Premier ATX?
According to Mr. Baird, Premier ATX are
Yes,
the
the
ones who have assumed responsibility for all his warranty work.
Are they Georgetown?
Yes, ma'am.
yes,
Okay, that's why I'm getting confused because it's Premier
I'm sorry.
ATX, but you're talking about Georgetown. That's where my loss was there. Okay.
Yeah.
sorry.
Okay. No, that makes so. Mr. Baird tells you that you have a claim, but your claim should be filed with Premier ATX. They've said that's not true. We don't own the warranty.
Correct.
Okay. All right. Thank you very much then. All right, Mr. Baird, would you like to make an opening statement or would you like to wait?
I can wait. Thank you.
All right. Mr. Truesdale, would you like to make an opening statement on behalf of your client?
Thank you, Your Honor. I would just say that we, on behalf of Premier, we do not have a contract, and we have no relationship that would require us to make the repairs. And so I will wait for other arguments to be made, but we're kind of strangers to this transaction. We did not build the pool. We did not inherit the pool. And we offered to contract to repair the pool, and our offer was not accepted.
The judge listens closely, already recognizing this is no small misunderstanding. It's a paper trail problem.
And so we were not retained to repair the pool. So and so that's basically our position. Thank you, Your Honor.
Thank you. All right, Ms. Ferdakis, actually, and Mr. Baird, are you able to turn on your camera? Mr. Baird?
It's mute.
Yeah, I'm working on it here for you.
Okay. Oh, fantastic.
There you
All
go.
right. If I could please have you and our plaintiffs, Mr. and Ms. Ferdakis, please raise your right hand for me. I'm going to go ahead and swear in all the parties. Do you understand that by appearing today and making testimony, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
Yes.
I do.
Right.
I do.
And Mr. Truesdale, do you have anyone here on behalf of Premier, or are you going it alone?
No, Your Honor, I have a John Curl with Premier ATX online. So I think that he's on the call as well. So
All right. And what is, I see it as that for the person who's named Premier Pool.
Premier Pool's one, I presume so. So yes,
What is his name?
John Curl, Curl.
All right, Mr. Curl, can you hear me if you'll unmute?
Oh, there we go.
Yes, I hear you.
Good afternoon, sir. And do you have camera? Are you able to turn on your camera?
I'm trying, but it's not allowing me to.
All right. Well, will you please raise your right hand and swear to the court?
Yes,
Mr. Curl, do you understand that by appearing today and testifying in this matter, you're swearing to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
yes.
Okay, fantastic. All parties have been sworn in then. We're going to start with plaintiff. So, Mr. Ferdakis, would you like to start first and present the information that you have for me?
Yes, ma'am.
Okay,
So
so let me ask you a few
the-
questions because I'll kind of lead us along. You did a great job of the opening. I get exactly what we're here for. So, okay, you contracted with Baird Services to have a pool built. I think you said that was in September of 2021.
that's correct.
And was that did y'all have a written contract for that?
Yes, we have submitted it in evidence. We have a written contract with Premier Pools, which is a franchise under Baird Services
Let's take
for the territory that our home was at.
Okay. Let's see if I can locate that in the information here. So I see a 22-page brief. Perhaps it's included in that. Let's take a look.
It's on our page.
And I'm going to share my screen. Mr. Ferdakis, if you tell me if you recognize this document. In fact, he builds the pool, you discover defects in the pool, you notify Mr. Baird about the defects you discovered. Does Mr. Baird acknowledge in writing that he's caused a defect or that the pool is defective?
The builder agreed to warranty repairs while still in business. That matters. The court isn't interested in excuses. It's interested in obligations, and those obligations are starting to look very real.
He did say that I will take care of it. I will fix it. I have multiple texts from him. He came to visit the home and he said, I will take care of it. And that went all the way from when I reported it in June all the way to November. November 2nd, as a matter of fact, it was the day that he came to visit. When I followed up with him about doing it in December, he said to me that I'm out of business now and please talk to Premier in Georgetown, who is taking care of all my work. I'm not quoting him verbatim, obviously, but that was the idea.
Okay, so you notified the defendant that the pool had a defect.
Yes, ma'am.
And did he in writing respond?
He sent me several texts stating that I'll come by, I'll take care of it. Yes.
Okay. Do any of those text messages acknowledge that he is liable to make the repairs?
Yes, he said, I will take care of it.
What day are those messages on?
Here.
So those messages, they start from the original. Okay, the one I want to I think is the more explicit is Exhibit 4, where we said in November 15th, it's on the list. I don't have a day yet from him. That's when we were asking specific scheduling. And then on November 29th, I'm trying to get the mason there. He's backed up due to the wet.
All right. Mr. Truesdale, do you have any questions for the plaintiff?
No, Your Honor. Thank you.
All right. And Mr. Baird, I'd like to hear from you next. So
Okay,
it doesn't seem to be in dispute that the pool needed to have repairs done. Why do you believe, or what information do you have to show us that the warranty is going to be honored by Premier in Georgetown?
there was a document, I don't have it with me. I think it's in that pack of documents you have that was signed between me and John and our corporate office, I believe. I don't remember the details. If John said that their pool didn't fall in the scope, I don't know the details on that. I know there was a general warranty that was being passed along when they took over my territory.
Have paperwork to support that?
I do somewhere. I do.
This
My
is
attorney
all due
had it.
respect, Mr. Baird, today is the day to prove that you aren't responsible
Oh, yeah.
personally for this.
No, I don't have it. No, I don't.
All right. Did you have insurance?
I did.
Are you required to be licensed by the state of Texas to install pools?
No, ma'am.
Were you a single member LLC?
Yes.
Mr. Truesdale, do you have any questions for Mr. Baird?
No.
All right. Just so I'm clear on this one, absolutely no one has anything in writing to affect that Premier ATX in Georgetown has a responsibility to take care of the pool warranty.
We submitted it.
Ma'am, we submitted, I think, the paper that Mr. Baird is referring to, and it is, it appears to be part of a contract that he gave that to us, as a matter of fact.
Is it part of the original, those 4 pages that I was looking at?
No, it was a supplementary submission,
September 14th.
September
If
14th.
that's the case, I have not seen any of the,
We'll get there.
Yes,
no,
you
that's
were
fine.
copied.
I just
No,
want
let's
to,
take a look. I get it.
Mr.
Okay.
Cruz, you were copied.
In the 22 pages you originally submitted, is it part of that brief or is it a different document?
No, it was a different supplemental submission. It was on
Okay, y'all have it in. All right,
September.
let me look through and see if we can
I'm
find it.
sorry. Okay,
Fine.
open.
And it was emailed to him.
Okay, it says business modification terms, March 1st, 2022. Parties, Baird Services LLC, Premier ATX Industries, and it is signed between Amy and Brady Baird and Christy and John Curl.
I have this marked as defendant's exhibit. Maybe it's mislabeled. Let's see.
that's correct.
Mr. Curl, would you like to ask him if he recognizes that this is his signature on this contract?
Yes, it is.
Okay. And so it says to assume warranty for a 12-month period, right? And this was signed February 2022.
That instruction alone is explosive. Because now the court isn't guessing. It has proof the builder himself redirected responsibility. And once you do that in writing, you don't get to pretend it never happened.
And their pool was built September 2021. So, Mr. Truesdale, with that information, does that change your client's response?
No, not at all. The warranty, no, it does not.
Well, this is clearly a contract between your client and the defendant, co-defendant, that covers warranties. And it seems to cover the type of pool that the plaintiffs are alleging had a defect. And I haven't had any information introduced that the defendant one, filed an insurance claim. And in fact, what they've shown me is that in text messages, he said, yep, we're going to send someone out to fix it in the Mason part, which seems to be under this.
Judge, if I may, with regard to
I-
insurance.
Mr.
No,
Ferdakis,
go ahead.
not necessary.
Okay, I'm
I'm right. It is never in anyone's interest to blurt out things. Mr. Truesdale, I'm asking a legitimate question here, right? So in October, they notified the defendant, Mr. Baird, about the problem. Mr. Baird in November agreed to get a mason and fix it. So there's no indication this is something beyond what is the scope of this. And then when it didn't get done, he said, hey, I'm selling. And that's probably because he was working on the contract. And that contract with your client was completed in February, which is in the 12-month period that this would be covered.
But the bottom line is that we never had any contract with respect to this particular pool.
I think it's covered right here.
well-
ATX will assume warranty for gunite periods built by the defendant one in this case, in the territory for 12 months. And your client signed it. And they agreed then to refer cases, to refer ongoing business forward on each other. So if that's not an assumption of the risk, I don't know what is.
Well, it's not assumption of the risk, it's assumption of any kind of contractual obligation, but I don't think that we assumed any obligations associated with Baird with respect to this obligation. We did not do that. I mean, that was not the point of the
What would be
contract. That
covered?
was-
What would be covered by this then, Mr. Truesdale? Because this absolutely says will assume warranty work for gunite pools built by the defendant in that 12-month period. And that falls within this. Otherwise, it wouldn't be here.
Would it help if I enlightened a little bit on this?
Yeah, Mr. Curl, because this seems to include that you guys are taking over warranties that he'd been given out.
Well, there was no purchase of Baird services. This is just a territorial thing within the Premier Franchise Management. But what it refers to, is my understanding at the time of signing, is that anything that was a structural defect, any cracks, anything of that nature has to go through Baird services or their insurance or whatnot. The general warranty as it specifies there, like pool equipment, plumbing, things of that nature that are kind of standard warranty items. But anything structural pertaining to shotcrete, and if they have any cracks whatsoever, that's what that's referring to, has to go back to them. And that's really all that it was. It was a way to allow Mr. Baird to get out of the it's an internal document. I don't really know all the details of what was going on, but on his end, but we didn't take on any major liabilities whatsoever, or anything really on this internal document.
What would you have been taking responsibility for if you said we will assume warranty? I mean,
So all the manufacturer warranties that apply to, a swimming pool. So for example, pool equipment, things of that nature that have
see,
a
that's-
manufacturer warranty.
I don't agree with that, Mr. Curl, because when I go back and I look at the contract that the defendant was giving out, it exclusively denies that. If it's a manufacturing situation with a pool equipment, the plaintiffs were required to go and file a warranty with the manufacturer. This is about the part that Mr. Baird performed, the building of it. And so it seems to wholly include that. Because when I look back at terms and conditions, number one, pool equipment and accessories installed carry a warranty by the manufacturer. So you didn't need to get that disclaimed. It's already taken care of in the original contract that Baird was giving out to his clients.
They didn't rush to court. They didn't exaggerate damages. They followed the contract. And when abandoned, they mitigated harm. Courts respect that, and this judge makes it clear she does too.
The contract between y'all says you take over things, which I can understand why. Mr. Baird, do you want to enlighten us? What did you think it meant? Because clearly you thought this covered your warranty, and that's why you referred the plaintiffs there.
Yeah, so the part in that internal contract with me and John Curl, the point that where we're missing all this is the structural items, the insurance claims. That pool is, and Truesdale knows about all the ASR going on in Austin. ASR is cracking every pool in town. There's thousands of pools broken here. The warranty that John agreed to do is not ASR related structural damages.
Why did you refer the plaintiffs to them to file a warranty coverage if you're now saying it doesn't count?
Yeah, because at that time,
did you lie to the plaintiffs when you sent them that
No.
message? Or are you lying now?
neither.
Then which is it? Because you told them you're covered, file a warranty claim.
Right.
It can't be both, Mr. Baird.
I agree.
which
When I
is it?
closed my, you ready? I'll go. When we closed our business because we had multiple pools cracking. We didn't know what was going on. We hired engineers. Come to find out, it's ASR, alkali silica reaction. Thousands of pools in Austin are breaking. We got out of the gunite game. I sold it from the time I turned it over to John. Within 6 months, I had my engineering reports on all the pools I had built that I needed to go to insurance with. We verified that it's ASR. And since then, we've probably turned in 200 pools for insurance. The people that shot their pool that provided the shotcrete is one of the biggest players in the shotcrete game, and they have thousands of cases against them right now. The ASR cracks pools. It cracks gunite shotcrete structures, which travels up through the tile, cracks the plumbing, cracks everything. The day I stood in their backyard, had no idea. I was just wanting to do fiberglass. Within 6 months of me having over 200 customers call and tell me their pools were breaking, we hired the engineers. We know what it is. So now everybody's getting turned into insurance.
Have
The
you filed an
Ferdacuses
insurance
know
claim
this.
for the plaintiffs?
They called the insurance themselves and found out that it was denied because of some.
That's not what I asked you, Mr. Baird.
What'd
Did
you ask?
you file an insurance claim per what you just said? Did you, on behalf of the Ferdacuses, whose work you did, and you said it's not my fault that it messed up, there's some other reason for it, have you pursued an insurance claim on their behalf since they're your clients and they gave you money and you told them you would take care of things? Have you done that for them?
No, ma'am.
And until today, had you ever indicated to them that it wasn't up to ATX to cover the warranty?
No.
Okay, Mr. Truesdale, do you have any questions for Mr. Baird? Mr. Ferdakis, how much money did it cost you to repair the pool?
$4,234, and I'm sorry, let me put up the cents. Doesn't really matter. 62 cents. 42.34.62.
And that's the amount that you're seeking?
Yes, ma'am.
And how much did you pay for the pool again?
78,250.
All right. Mr. Truesdale, do you have any questions for the Ferdacuses?
No, Your Honor.
Any questions for your client?
No, Your Honor. No.
Any questions of Mr. Baird?
No, Your Honor.
All right, Mr. Baird, do you have any questions for the plaintiffs?
No, ma'am.
Any questions for Mr. Curl?
No, ma'am.
All right. Just so I'm clear, $4,200 is 0.05% of the total price paid by the plaintiffs. Right? I do find that they've met their burden of proof today to show that they had a situation for which they gave notice to the defendant of it. Defendant did provide Defendant Baird provided them with information in writing, both in text messages and then later a supplemental document to indicate that they had a warranty that they could pursue with counter defendant or with second defendant here, Premier ATX. When I read that document, there is some not great language in it, but that is not to the detriment of the plaintiffs here. In fact, what I read seems to include that. So I am going to find in favor of the plaintiffs against both defendants in the total amount of $4,234 plus their cost of court. Again, this is a small claims justice court, which means we're not a court of record.
He message is unmistakable. Warranties matter, words matter, and written promises follow you into court. With that, the parties are excused. Another case closed, and another reminder that paper trails don't disappear just because someone wants them to.